travel isn't just about destinations. It's about the people you meet, the cultures you immerse yourself in, the stories you carry home. I'm Relebogile Mabocha, and on my travel feature, I take you on a journey beyond the guidebook. Each week, I connect with fellow travelers, insiders, and storytellers to bring you the heart of every place. Whether it's a hidden gem right here in South Africa or a dream destination abroad. Join me as we travel through conversations, memories, and inspiration. Listen wherever you get your podcasts.
702.
World of Work.
Let's get into our World of Work feature now. Today, on our World of Work, we are discussing something we often talk about that's often in the news, golden handshakes. What do you understand about golden handshakes? How many times has government or even private companies paid golden handshakes to employees to avoid further reputational damage or protracted legal battles? And what does the law actually say about golden handshakes? Because this term is often referred to as sort of a payment to an employee, mostly at executive level, who retires early or is made redundant, for example, owing to restructuring or a merger or an acquisition. But it can also apply where companies just wants to get rid of you, right, to avoid a fight. You know, when the payment is made to an executive who has contributed years positively to the organization and it's probably approved and declared by the organization, that's now considered acceptable. But when golden handshakes happen in a way, maybe even in the public sector, where they are viewed negatively because you're trying to push someone out or because you don't want a protracted battle, that's when it's regarded negative. So we've invited someone who's going to help us understand how this works, what the law says, if do we even have any that governs such agreements. Advocate Tertius Wessels is the Managing Director at Strategy Labor Solutions, joining us on the line. Advocate Wessels, thanks for your time. Hi.
Hi, good day, Clement, and good day to the listeners. It's great to be a part of your World of Work feature.
So the term golden handshakes, how I've come to really interact with it is when I've been reporting over the years about the many golden handshakes that we saw in government, whether it's the Eskom CEO back in the day given the golden handshakes because government wanted a different CEO and this one is refusing to leave, or Transnet, or how do we define it and what justifies it? Is there a general law that does, or it depends from company to company?
Yeah, I think you hit the nail on the head, when you spoke about your understanding of what golden handshakes are. And we more commonly also know them as the so-called mutual separation agreements. And they are often entered into in an attempt to reach an amicable termination of the employment relationship, or, like you mentioned, avoid these time-consuming and often very costly disciplinary hearing processes and subsequent unfair dismissal disputes or labor court proceedings. But yeah, in essence, the main issue that we experience, and I think that where we often see public outcry, is the fact that we don't really have any laws or regulations that govern golden handshakes, especially in the public sector. And that becomes problematic because it's almost seen as a misuse of taxpayers' money, just to pay away the problem.
Yeah. So can you give us a sense of when and why an employer might choose to offer a golden handshake instead of following the standard, termination procedures?
Yeah, so I mean, one scenario that comes to mind is where there's often grounds to suspect that an employee is guilty of a very serious act of misconduct, or where the employee is no longer considered suitable for their position within an organization. An employer would normally then institute disciplinary action by way of issuing notice. And at that particular point in time, they would engage in a discussion about the possibility of parting ways on an amicable basis. And that's simply to, on the one hand, ensure that the employee gets to walk away with a clean disciplinary record, so to speak, and the employer doesn't have to go through the tedious and often time-consuming process of a disciplinary hearing and then having to defend their decision at CCMA. So there's almost this compromise that the parties try and reach in order to save themselves certain hardships that they might experience if they had to go through the process. But, in essence, that shouldn't always be the case. I always believe that, if there are grounds to suspect that somebody has committed an act of misconduct, our law provides for the disciplinary hearing process. And we should be following those processes instead of just paying for the problem to go away.
So for maybe, people listening to us who are in this situation right now where a company is offering them a golden handshake, what's important for those employees to do first? Like, should they be seeking independent legal advice, for instance, before signing such agreements? What would you advise them to do?
Yeah, I think it's important to understand that over the years, our courts have interpreted golden handshakes or mutual separation agreements as being lawful and legally binding contracts, meaning that both parties must uphold their obligations. So it does become important for an individual that is considering accepting a golden handshake to really consider what are the benefits attached to it and what are the potential consequences should they elect not to accept it. Very often you may find that an employee that potentially knows that they have done something wrong can see the writings on the wall, in which case if they are then able to receive a bit of additional remuneration just to walk away, it becomes an easy sell for them. But where a person is really innocent of any alleged wrongdoing, they need to take proper legal advice in order to understand what the consequences would be if they accept it, because very often these agreements include a clause in terms of which the individual would waive their right to approach the CCMA or the Labour Court or bargaining council for any further relief. And it becomes only in instances where you are really able to prove that you were forced or coerced into signing the agreement that you really have a basis to even try and challenge the validity of the agreement.
But sometimes those agreements can be made stringent, right? In that if you're signing this and we give you this amount of money, then you can't really speak about certain things or maybe even speak about the departure. I mean, I'm thinking now of the former UCT Vice Chancellor, Professor Mamokgethi Phakeng, for instance. Whenever you would want to ask your questions about, okay, how much did they pay you? What happened? Often she says she can't say. Even the institution itself can't say how much money exchanged hands for her to end up leaving like that. So are those some of the, are you at a better position to negotiate that? Can you go, okay, yeah, pay me that money, but I still want to be able to speak about this maybe after 6 years. Or I still want an option to, chat about it. Should I do an interview or whatever? Are you at a better position to negotiate, or is more the employer who's got the upper hand?
Well, look, both parties have bargaining power. And, at the end of the day, a person that is wanting to retain certain rights, loses a bit more demand for payment. If I eventually want to say, but I want to be able to have interviews about it, I want to be able to speak publicly about the reasons why we entered into it, etc., and how much I got remunerated, then an employer would be inclined to pay less for it because they don't want to be seen as having paid this exorbitant amount of money for no apparent reason, just because somebody was perceived as uncooperative or a troublemaker without there being any real evidence. People would think twice about how they engage with that particular organization. So yes, you have the ability to negotiate all the terms that are set out, including the confidentiality terms. But where it's a give and take scenario at the end of the day.
And I mean, when you negotiate, then the golden handshake, should it represent, like, if I still had 4 years to serve here at 702, let's use that as an example, touch wood, and I decide, okay, since we are now parting our ways, then pay me the remainder of the 4 years, the amount. So you pay me what you would have paid me in 4 years, or can the amount that gets paid in a golden handshake, can it exist outside of what the company was supposed to pay you for the remainder of your contract?
Yeah, look, I think there is no limitation in as far as payments is concerned, and I think that is a big problem that we have in as far as our legal framework surrounding golden handshakes are concerned. Is there's no obligation on parties to disclose. There's no limitation, especially in the public sector, as far as how much can be paid, etc. So you can almost be rewarding bad behavior to the degree that your checkbook allows it. But obviously it doesn't really make sense for an employer to pay you more than what you are contractually entitled to, because, I might as well then just say to you, listen, fine, I'm terminating you with immediate effect, and I pay out the balance of your contract. We don't even have to negotiate anything.
Yeah, all right. Advocate Wessels, there are some people listening to us now who are sending us their WhatsApp voice notes. Some of them have actually received these golden handshakes. So let's listen to their stories.
Sia here is in Churon. I got a settlement from one of the SOEs because they knew that they didn't have a case. I was dismissed without following the procedure. So what happens? They have to cover themselves, reputational risk that it was in front of them. And I accepted because I just felt my life was in danger. I left.
On my depart with the golden handshake, the agreement was confidential. So me or my previous employer were not allowed by law, after signing the agreement, to discuss anything that was related to the case, even though I was innocent and they could not prove me, because my thing is that I did not want to resign. So I refused to resign even when they wanted to corner me, until I was offered a way out of a mutual termination. But that I took because the trust relationship was broken, because I was no longer going to be able to trust my employer, because anything I was going to do after that, perhaps they were going to find other reasons to fire me instead of what they had initially accused me of.
Yeah, and I suppose, Advocate Wessels, if the company has a strong case against you, why not let the law take its course? Like, why not let a disciplinary process? Unless the company is not too confident of their case and they're like, we're likely to lose more money here and waste more time, so let's rather pay this person out. Because from these two examples that we've just gotten, these people are saying we didn't do anything wrong. They decided to pay us out, and we took it because the trust in the relationship was broken, or because my life was in danger, and not so much because I believed as an employee that I've done something wrong and I'm probably going to lose this case.
Yeah, you have to ask yourself the question. There are those instances where an employer or an organization does not necessarily have the proof that you are guilty of alleged wrongdoing. And it might just be that you stepped on the wrong toes. And as a result, you are now labeled, a problem child within the organization, in which case they would, approach you and offer you a lucrative golden handshake, because otherwise, why would you even consider it if you are innocent? So they have to offer you a favorable or lucrative golden handshake in those instances. But where there are sufficient grounds, the disciplinary process should be followed, and the person should be terminated accordingly. And disciplinary hearings, by their very nature, are supposed to be informal processes, not like a court of law that we're attending here. And all that we're really trying to give effect to is to, for each party, the employer and the employee, to state their case, to call witnesses and to ask questions. And then for an impartial and independent third party to assess that evidence, determine whether or not the individual is guilty or not guilty. And in the event that it's not guilty, that should be the end of the inquiry, and we should be able to move on with our lives as per normal. And if the person is guilty and dismissal is an appropriate sanction, then so be it. Let the employee then exercise their right to go to the CCMA and, yes, go through the motions there as well. Because ultimately, if we had to get into this habit of just paying people off the whole time, what's the point of us even having legislation that governs conduct and performance in the workplace?
Absolutely. What's the point? Advocate Tertius Wessels, you've been great as always. Thank you for making time for us. Managing Director at Strategy Labor Solutions.